Hey everybody, this is Mr. Moffat coming at you with another APGov video. We are continuing to take a look at topic 1.5, focusing in on the ratification of the U.S. Constitution. Last time we talked about the Constitutional Convention itself and some of the major debates that would define that very historic meeting. What we're going to do in this video is just do a very good kind of just a once-over on what the actual structure is of the Constitution from start to finish, at least in its original form. So let's go ahead and take a look here. When we look at the Constitution, you go all the way back up here to the top, the very first thing that is in the Constitution is what's known as the Preamble. Now, as you can see here, it says in the Preamble, "We the people of the United States," which certainly tells you right off the bat that this is coming from a sense of government is organic. It's coming from the people, not from up on high, down on the people. Certainly Enlightenment influence there. It says, "We the people of the United States, in order to form a more perfect union," so in other words, to try to create the best government that we can, and you can even imply an improvement upon the previous Articles of Confederation. They state that they will establish justice, ensure domestic tranquility. That means peace and safety at home. Provide for the common defense. Don't knock the founders on misspelling defense. That's how they spelled it in those days. Promote the general welfare. The idea of trying to make things good for everybody on the whole, and secure the blessings of liberty to ourselves and to our posterity, meaning for us now and to our descendants in the future. Do ordain and establish this Constitution for the United States of America. Now, you might look at this and go, this doesn't provide any of the actual nuts and bolts framework of the government. It's not talking about any of the individual branches of government, or it doesn't talk about how to amend the Constitution. So what is the function of this preamble? Well, for lack of a better term, it's a mission statement. It's telling the people the overall goal and purpose of the Constitution. And if you understand, the social contract and whatnot, this is basically the government's side of the contract. The government is promising to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty. That's the function for this entire government. That's its job. And theoretically, if the government does not live up to the values of that mission statement, well, you can argue that that government has failed to meet the needs of the people, and therefore, perhaps another government should be created to replace this if it does not live up to these standards. So you can definitely see the values and the Enlightenment infused in the preamble there. Now, once we get past the preamble, then we do start to get into the nuts and bolts of the framework for the Constitution. Articles 1, 2, and 3 are focusing in on the branches of government, your big three. Now, you'll see here that Article 1 is focusing in on the legislative branch. That's talking about Congress. So it's primarily talking about the powers of Congress. It's talking about how representation would be determined in the House, representation based in the Senate. It's talking about elections for those particular offices. So pretty much, all of the powers of Congress and who gets to be a member of Congress, those qualifications as well, how they're chosen, all that's in Article 1. When you get into Article 2, same kind of thing, except now we're talking about the executive branch, the enforcement branch. So you're talking about creating this position called the President of the United States, talking about who is constitutionally eligible to become President of the United States, how the President is chosen. That's the Electoral College piece. It goes also into the details of what the specific powers of the President involve. Then you get into Article 3, the judiciary branch, and just like the other two, it provides a framework for the creation of the federal court system, including by name the U.S. Supreme Court. Fun fact: if you look in the third article, when you're looking at the judiciary branch, not only does it address the courts, that last section here in Article 3, as you can see here, actually provides the definition for treason. So yeah, it's kind of an interesting place to put it. I guess the idea being is that it's a criminal thing. So I guess you put it with the courts, but yeah, that does include that. Now, something else to kind of keep in mind when you're trying to keep the order straight in terms of how the branches are mentioned in the Constitution, because with Congress being mentioned first, then the president, and then the courts, that's not by happenstance. That's not by accident. That's by design. If you actually look in the Constitution, there is way more devoted in the Constitution in terms of actual words and pages to Congress, way more than what you see for the president. But even the president certainly has way more information for that position than the courts. The courts are almost an oversight. You can see here that there's not much here for the courts. You can see this is all of Article 3. That's it. That's all there is to it. So what's the reasoning behind that? Well, the basic gist of it is that the founders clearly intended that amongst the branches of government, that Congress would be the driving branch of the government. That's why they gave it the most explicit powers. It was assumed that American government at the federal level would be driven by Congress, and that the president would be down the line. So in other words, the thought was that the Congress would kind of drive what the president does. Now, that's kind of interesting today because in many respects, it's kind of flip-flop. The president kind of drives what Congress does at this point in time. And then you can see that the judiciary was of such relatively low priority that they're put in third. There's very little language actually devoted to the federal court system. So you can kind of see, who the founders intended favorites were. They envisioned a Congress-driven federal government for sure. So think of it in terms of that prioritization. Congress, then the president, then the courts. Now, for most Americans, that's kind of what they know about the Constitution. That's it. But we're going to go beyond that. If you go into Article 4, you're then talking about relations between the states. If you look at Section 1 right up here, it talks about the idea that full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. What this is talking about is that if you have a legal document that is legal in one state, it is then legal in every other state. So, for example, the issuing of marriage licenses, that's a state power, not a federal power. So if you live in Ohio and then go get married in Las Vegas, Nevada, you get a Nevada marriage license, but still, though, that marriage license is valid in all 50 states, including Ohio. Section 2 is talking about what we call the Privileges and Immunities Clause for the Constitution. What this is basically talking about is that you cannot, deny equal, well, I shouldn't say equal rights, but the idea being is that you cannot favor the residents of one state over the residents of another state when it comes to state rules. So, for example, you can't say on a road in Ohio that the speed limit for Ohioans is 70, and and say, oh, that's because Ohioans are better drivers than Michigan drivers. So if you're an out-of-state driver from Michigan, then the speed limit is 60. Like, you can't set those different speed limits. In other words, everybody has to follow the same rules in terms of what the state issues. Now, there are some exceptions. For example, things like hunting licenses, fishing licenses. They do make exceptions for that. Probably the most well-known one is college tuition. For example, when you're talking about public schools in Ohio, there are what we call in-state rates, and then there's out-of-state rates. Well, what's the story behind that? Well, technically, the school does charge everybody the same amount of money to go there. But the reason there's an in-state versus out-of-state rate is because the state of Ohio pays a portion of that tuition for all in-state residents, where the state of Ohio, for example, would not pay that for out-of-state residents. Well, why would they do that? Well, because if you are a resident of Ohio, you are paying Ohio taxes, so they're going to use that tax money to help you as an Ohioan. So that's kind of an exemption, if you will, if you think about it, to the Privileges and Immunities Clause. So it gets into also rules about, most of Article 4 is talking about interrelation of the states. So it's talking about, rules in terms of state sovereignty, things like that. Every state's required to have a small r Republican form of government. that kind of thing. So it's mostly relationships between the states. When you get into Article 5, this is the amending portion of the Constitution. It talks about the 4 official ways that you can actually amend or change the Constitution. And what it involves is that when we talk about amending, it is actually a 2-phase process. If you look at this right here, you'll see that in each of the 4 different ways that you can constitutionally amend this government, it starts with what we would call a proposal phase over here to the left, and then what would be a ratification phase over here to the right. So no matter how you slice it, there's always 2 phases that have to be done. Proposal phase, ratification phase. Now, per the Constitution, there are 2 ways that you can formally propose a constitutional amendment. It first has to start at either a 2/3 majority of Congress, that's both chambers, and, excuse me, 2/3 majority of some sort of national convention designed for the purpose of proposing that amendment. Now, once that part is done, it still has to go through the ratification process. So it doesn't matter which of these 2 ways you propose it. It's still, for it to go into effect, it has to go to the ratification portion, which involves either state legislatures or state conventions. For it to be ratified from the proposal stage, you have to have either 3/4 of state legislatures approve it. So that means 3/4 of states with a simple majority approving it, or 3/4 of the simple majority vote of what would be state conventions. The idea being of state delegates coming together to consider that specific constitutional amendment proposal. So you look at it, it's 4 different ways. Now, note, you'll see, federalism in action here. You're going to see, the national level at one stage, that's the proposal stage, and then the state governments at the ratification stage. So you can see federalism in motion there. And then you can also note that we are looking at different thresholds for achieving success. As you can see here on the proposal stage, you have to get a 2/3 majority, whereas at the ratification stage, it's a 3/4 majority of these various states. So as you can see here, supermajority is needed at both levels. So it's very hard to do. You got to get national approval, state approval, supermajorities. Very hard to do. That's why it's only happened 27 times. And of those 27 times, 26 of them were done the same way, starting with a 2/3 majority of both chambers of Congress, and then followed by a simple majority vote by 3/4 of the various state legislatures. The only exception to this was the Congress to state convention format, which led to the 21st Amendment, which was the repeal of prohibition. Rounding out the original Constitution after the amending process is Article 6, which mostly deals with the Supremacy Clause. It basically says that the authority of the United States shall be the supreme law of the land. So this is talking about issues with federalism as well. If there is a conflict between federal authority and state authority, per Article 6, what we call the Supremacy Clause, the federal government is supreme, therefore it wins out. It also includes in here, it says that there shall be no religious test to hold any federal office. That's kind of an interesting thing. This is before the First Amendment freedom of religion provision, but it does say that you cannot apply a religious test or religious qualification to hold any federal position. That's pretty progressive. And then the last thing to kind of round it out, in Article 7, it says what it requires in terms of this plan for government, which is what it was initially, for it to actually become ratified, to actually now become the official government of the United States. And that would require 9/13. So now, of course, we know every state has eventually ratified the Constitution. So that's how it goes, from Preamble to Article 7. But note, one major part of what we now have with the Constitution was originally not in it. That's your amendments. That's your amendments. Starting with the first 10 known collectively as the Bill of Rights. And that is where we will pick this up next time. We'll see you later. Bye-bye.